Good morning. Good morning, everyone. Welcome to Law Week. Welcome to the Office of the Public Advocate's Law Week event. This is actually our first public webinar, so we're very pleased to be here today. My name's Hilda. I'm the Education and Engagement Officer with the Office of the Public Advocate. I've been in this role for about 5 years, and probably most of you have had some interaction with me in regards to this webinar. So welcome. I'll give some people a few minutes just to settle in. There might be people joining us a little bit late and trying to become a little bit more comfortable and familiar with this platform. I know we are. As I said, this is our first public webinar, so we welcome you very warmly. We have actually got about 113 people registered today, so we're very pleased. And we did realise that if we had held this event in the office, we wouldn't have been able to accommodate that many people. So this pandemic has been obviously a very interesting time for everyone. And we are learning, learning new technology, becoming probably a lot more comfortable with these kinds of platforms. Unfortunately, we did have to cancel a lot of our education events, and it's taken a little bit of time for us to move online. So this is a big day for us. So before we kick off, I guess I wanted to acknowledge, of course, the traditional custodians of the land on which we meet. And we are coming from all different places today. And I will let you know who's in our audience. But I did want to pay my respects to the custodians of this land and pay my respects to their elders. So just to tell you a little bit about how today's going to work out and how it's going to play. For some people, it may be very unfamiliar. I know when I first attended my first webinar, I had no idea. So let me tell you just a little bit of information that might help you. We are what is called, I guess, in the mode of a view and listen mode. So while you can see us, we can't see you. So if you want to go grab a cuppa, you have to pop to the loo or just grab a drink of water, please make yourself comfortable. We are going to be taking you through for about an hour. So there's quite a lot of content to cover. So we'll take it slow, but we'll also allow for enough time towards the end, we hope, to answer most of your questions. So, and we also do ask for understanding if we're unable to get through all the questions, because as I said, we do have a large audience, but we'll do our very best. Just a couple of other things. You can engage with our presenter via the Q&A function. So if you're not familiar with that, it's just a little button at the bottom of your screen. You can type in a question. So that's how we're going to take questions, via that Q&A function, and that will be moderated by an OPA staff member who I will introduce shortly. So other thing, I wanted to introduce you to Claire. Claire is our legal officer, and she'll be taking you through this presentation. But just a little bit about Claire, so you know, I guess, where she's worked and what she's done. Claire's actually got a long-standing relationship with OPA. She's been at OPA for about 15 years, and she started back in 2008. Is that right? No, 2005. So Claire joined OPA in 2005 as an advocate guardian, and then moved into the role of the legal officer in 2008. So Claire, actually, her work involves resourcing and advising OPA staff on the various legislation that is relevant to our work. So she does all the training for our staff and is also there as a legal resource to us. Claire's delivered many presentations to health professionals, legal practitioners, and the general community. And her commitment to legal education began many years ago when she was working as a lawyer in the Community Legal Centre. So you'll be in very, very capable hands today. Also joining me is Emma. So Emma is our Legal Education Project Officer at OPA, and she started almost about the same time that I did. So she's been around for about 5 years. Now Emma's work involves working on OPA's publications and also specific projects. And one of the exciting projects that Emma is now involved in, and it's just kicked off, sponsored, funded by the NDIA, is a project that's called Healthy Discussions Supporting People with Disability to Make and Communicate Health Decisions. So Emma has a background in law and prior to OPA also worked in the Community Legal Centre. So just a little bit about how to stay in touch with OPA. If you're interested in the work that we do, for example, that project that I just mentioned, please, I strongly encourage you to sign up to OPA Updates, which is a newsletter that is sent out to mostly health practitioners, social workers, people in the community services. I also wanted to just signal out who we have in the audience, so you know who's sitting with you in this remote audience. We have representatives from various health centres across Victoria. So the major hospitals, we have people here from Melbourne Health, Barwon Health, the Alfred, Monash, the Epworth. So a warm welcome to you all. We also have a large group from Geelong. Welcome to you. We have quite a few people from the Rights Information and Advocacy Centre, so that's REAC, so welcome. We also have a few people from Ballard, representatives from Victoria Legal Aid, Services Australia, the Judicial College. So really a whole range of people, and of course members of our community and the general public, welcome. And a special mention, of course, to our representative from the Victorian Law Foundation. The Victorian Law Foundation runs this Law Week event every year, and so we're very happy and glad that you're able to join us today. So I will be off camera shortly, and I'm going to hand over to Claire, who's going to take you through this presentation. Thanks for joining us. Claire, over to you. Thank you.
Okay, thank you, Hilda. Hopefully now what you can see on your screen is a PowerPoint presentation I'm going to take you through. So in terms of the time that we have, I was proposing to spend about an hour doing this, and that should leave plenty of time for questions. So just type your questions as you go, and at the end we'll sort of synthesize them, and if things weren't covered, I'll try to cover them, or things require elaboration, I'll do that as well. There's a slide about the acknowledgement to country, which Hilda's covered. Thank you. Now, the impression I get from the attendance list that Hilda's just taken us through is there's quite a lot of professionals from the health sector and the legal sector, and you might be quite familiar with our office. You might have called our advice service, or you might have been involved in investigations. Our office has been involved in it, VCAT, etc. But of course, there'll be those of you who have logged in because you're not that familiar with all these things. So just very briefly to explain who the Office of the Public Advocate is. The Public Advocate is Colleen Pearce, and the position of the Public Advocate is created in the Guardianship and Administration Act, and it sets out the functions of the Public Advocate, and obviously Colleen as the Public Advocate delegates all those powers and duties that she has to the staff in her office. And as a staff group, we nudge over about 100 people, but there are also several hundred volunteers involved in the various volunteer programs of the organisation. So put most simply, we call ourselves OPA, so out of habit, that's what I'll be saying. We've got two fundamental responsibilities: to protect the rights, to protect people from abuse, neglect and exploitation, and to promote the human rights of persons with a disability. Now, the Act I'm taking you through now, the Guardianship and Administration Act 2019, is a new piece of legislation, but it follows on from a previous piece of legislation. Many of our functions remain the same. There are a few differences, but they're probably not so relevant for today's discussion. Just in terms of the sort of coding technique, I guess, in the PowerPoint presentation, if I've put a word in a different font colour, it usually means because there's a legislative definition. So you'll see the word disability there. Now, there'll be people in the general community who perhaps have a mental disorder, but they don't necessarily regard that as a disability. So I appreciate that, but I'm using legislative definitions here. And this is what the legislation says. It says disability includes neurological impairment, intellectual impairment, mental disorder, brain injury, physical disability, and dementia. Most of our work is really more with the cluster of cognitive impairments rather than physical disability. And the part of that definition which is new to this new Act is neurological impairment. That wasn't in the previous Act. I'm also going to refer a fair bit here to VCAT. So that's the Victorian Civil and Administrative Tribunal. Most people know it as VCAT, and again, that's my habit. I'll be calling it VCAT. Now, I know this is a really busy slide, and whilst my topic today is the Guardianship and Administration Act, if you're involved in matters before the guardianship list of VCAT, odds are you've got an application that crosses over into other legislation. So there's also the Powers of Attorney Act and the Medical Treatment Planning and Decisions Act. So I'm not going to cover those last two acts, but for those of you who would like to learn a bit more about that, the Law Institute of Victoria has got a webinar on Thursday between 5 and 6:30 p.m. where all three of these acts are being spoken about. So if you want to have the opportunity to see a little bit more the interplay between them, that would be an opportunity to do that. The reason some of these slides are quite busy is that I hope they're a useful resource for people afterwards. I know there's often a little bit more text on the screen than you're meant to really do in a PowerPoint presentation. Okay, so let's talk about the Guardianship and Administration Act 2019. It started operation on the 1st of March 2020. That was a date in our office we had been counting down to since it had been passed by Parliament. I can't remember the date that was. It was in April or May last year. So we had less than a year to get ready for its implementation, and it was a lot of work in our office, required most of our resources, or really nearly all our resources, to be reconsidered. And of course, the 1st of March as a date of significance pales really into insignificance compared to COVID-19. So fortunately, we had good time in the office to get ourselves organised about the Act. Unfortunately, we found ourselves working remotely pretty quickly after the commencement of it. So some of the principles in the Act aren't set aside because of COVID-19, and I will explore that a little bit. But of course, we can't ignore the current circumstances. The nature of legislation is you can't really have a ground zero. So whilst Parliament might introduce new legislation and have reform, they can't really just scrub out what went before. Well, certainly not in this area, because prior to the 1st of March, guardianship and administration orders had been made by VCAT. And some of those orders would have been made as late as February 2020, and they might have been made for a year or 3 years. And if that's the case, what's the status of those orders? It would be impracticable for every single matter to come back to VCAT on the 1st of March to start under a completely new framework. So essentially, we've got a transitional phase where we will have orders made under the old Act and we will have orders made under the new Act. And some of the provisions of the new Act apply to people who are guardians and administrators, but most of the provisions of the old Act still apply if the order was made before that. So again, as we go through this, I'll try to explain some of those things. But if there's a hearing before VCAT now, if there's a new application before VCAT, VCAT is dealing with the new legislation. So if somebody was to ask me, what's the most important thing about this new Act? What is different about it to the old Act? I would say it's the very explicit reference to human rights. Now, at one level, that's not that surprising that we would consider that this should be an area of human rights. And it's not to say that before the 1st of March 2020, those of us working at OPA and at VCAT and in lots of other areas weren't interested in talking about human rights, because we were. There's also the Charter of Human Rights and Responsibilities Act. But you need to understand the history of legislation. It's born of the social momentum of its era, and Parliament hopefully reflects that. So the 1986 Act was very much about the shift in the community at the time about deinstitutionalisation. And now that might seem so straightforward to us that people with disabilities shouldn't live in institutions, because we've had that period of several decades now where that's been implemented. And this new stage is about emphasising human rights. And simply because the legislation says something doesn't mean it happens. It doesn't just happen like that. It will happen because all of us, people who are concerned about people with disabilities, people who do have disabilities, collectively, we all need to be emphasising this focus on human rights. So it's a general discourse, and if there's a discourse in the community, you start to see practices hopefully being different. So the human rights focus is the most important thing. And you'll see I've said that there's a shift away from best interests. So this expression, best interests, does not appear in the new Act at all. Instead, there's an expression, will and preferences. And again, just bear with me, there is a logic to sort of the way I'll unfold the information. I will come back to that. I think many people are very familiar with the idea of making decisions based in someone's best interests. And in fact, I challenge anyone just to pay a little bit of attention to this, because I would think that in the space of a week, you probably do refer to something being in someone's best interests, whether it's a client you're working with, whether it's your sister, whether it's your mother, whether it's a colleague, you will find yourself using this expression. It's very entrenched in our community language. The second thing, and it flows from the human rights focus, is the emphasis on providing support to people with disabilities to make decisions. And that manifests in a couple of ways. One way is that VCAT can actually appoint someone to be what's called a supportive guardian or a supportive administrator. And even though we're still in quite early days of the implementation of this Act, VCAT have made a few of those appointments, and they're certainly considering it. And again, I'll come back and explain this in more detail. I think a little bit more importantly, actually, is the second aspect, which is the obligation for all of us to support people to make decisions. People with disabilities of different types for different reasons might need a bit of support. They could make a decision if they got that support. So rather than a disempowering model of saying someone can't make a decision because they've got a disability, our interest is more about, well, how could we empower that person so they could exercise their legal agency? So anything I say from now on is going to be really informed by those two key points. We've got a slide here that Michelle Browning, who is the principal of an agency called Decision Agency, she has been an employee at OPA in the past, and she has been engaged as a consultant with our organisation, and she's been doing some really terrific work with us around supported decision making. And this little image that she's put together, I think, is designed to replicate the idea of this major paradigm shift. And if you think of the notion that I presume most of us ascribe to, that the Earth revolves around the sun rather than the sun revolving around the Earth, that shift in thinking is a little bit of a similar idea of what she's trying to get here. That really we want to put the person with a disability absolutely at the centre of things. So I'm not going to read through all those points. You can look at them in your own time, but often for people, obviously some of those visual suggestions are very helpful. With any piece of legislation, or generally that's my experience with the legislation I work with, it'll start out with saying what the objects of the Act are. And whilst they're not the provisions that many people, perhaps apart from lawyers, will look at, it informs how you understand the Act. So as we go through this, you'll discover there are some things the Act has defined and some things that the Act hasn't defined. So one of the ways you try to understand, well, I wonder what it means, is to go back to the objects of the Act. So that's just a statutory interpretation principle. So what's really pleasing, I think, certainly from OPA's perspective, is that the legislation is absolutely explicit about referring to human rights and the Convention on the Rights of Persons with Disability. Sorry, there's a typo there. So that's an international convention to which Australia is a signatory. And the Victorian government over the past period of time, through this Act, but also through the Medical Treatment Planning and Decision Act and the Powers of Attorney Act and the Charter of Human Rights and Responsibilities Act, and no doubt other legislation, but they're the ones with which I'm familiar for my work, have had in mind the convention. But this is the first time it's named explicitly. So there it is, and that is a very helpful thing, because the nature of human rights is it's a common discourse. Hopefully it's a language we all understand, and it's something that's relevant to all of us. Part of the other objects of the Act are that VCAT can set some safeguards and limitations on powers and provide guidance and regularly review orders. So we'll just wait and see perhaps how that plays out, how VCAT chooses to do that. But the idea of a sort of all-encompassing, give all the powers in the world to a guardian or administrator, this is what this is designed to set some limits to. In fact, one of the expressions in the old Act about appointing someone to be a plenary guardian, that's not in this new Act. And when you looked in the old Act about what a plenary guardian is, it's the language used is extremely paternalistic. I mean, it's literally paternalistic. It's all the powers that you would have as if you were a parent and the represented person were a child. So that paternalism is not the flavour of this new legislation. And when I say this, I don't want anyone to think, oh, I'm criticising VCAT, not by any means. In fact, plenary orders over time became increasingly rare. They were naturally becoming extinct, and it's just not the way this Act lends itself to the making of orders anymore. One of the things that's extremely important about this legislation is this test for decision-making capacity. So I will spend a bit of time on this. At one level, it's not complex, but in application, obviously things can start to get a bit complex. And so some of you might have some questions that you're interested in posing. Perhaps we could come back to about this. This definition is in the Powers of Attorney Act, and it's in the Medical Treatment Planning and Decision Act. So partly what we see in the Guardianship Act now is more legislative consistency between those three very interrelated pieces of legislation. In the old Act, it spoke about, in terms of the criteria for the appointment of a guardian or an administrator, if the person, because of their disability, was unable to make reasonable judgments about matters. This definition asks you to look at the decision in question. So what you can't say is that Rosie Parker has dementia, she can't make decisions. You cannot say that. If you're a medical professional and you put a report like that to VCAT, VCAT I would expect would give very little weight to such a formulation, because what is required is that you know what the decision is. So let's imagine Rosie Parker has been living at home. There's been some event, she's ended up in hospital, she would like to go home. Treating team at the hospital think, not so sure that Rosie can manage to live at home. She's not understanding what we're saying about the risks. And we're not sure that's a decision that she can make. So you hone in on the decision. Is the decision about where she lives? Is the decision about with whom she has contact? Is the decision about whether she sells her house? So then, you know, when you've got clearly in mind what decision you are talking about, let's stick with Rosie Parker in a gem ward in a hospital wanting to go home. So, and make about a decision about accommodation. So you have a conversation with her. Can she understand the information relevant to the decision? Now, the fact that she might make a different decision to the decision that you would make is not part of the test. Whether she would make a reasonable decision is also not part of the test, because that's a subjective analysis. The question is whether she can understand the information. So let's imagine Rosie Parker's house burnt down in the bushfires, and she says, I want to go home. And you say, well, look, Rosie, I'm really sorry to tell you this, and maybe you don't recall it, but your house burnt down in the bushfires. If she can't understand that information, then you've clearly got a trigger that maybe this isn't a decision that she can make. Can she retain the information to the extent necessary to make the decision? Now, people might have memory problems. Maybe all of us know that there are areas where our memory is not so great, and we have compensatory systems. I certainly do. I need to write things down. The process of writing them down and also having the record to refresh my memory is really important. So how long does somebody need to retain that information? Well, there's no case law for me to give you anything definite about that. And irritating as this will be, because it's the sort of thing lawyers say a lot, the answer is it depends. I did a session on this topic with a group of geriatricians recently, and the question that was put to me was, I spoke to one of my patients, and we would talk on a Monday, and she would say that she wanted to do blah, blah. And then I'd talk to her on a Tuesday and would go through it again, and then she would say the opposite. And then I'd speak to her on a Wednesday and she'd say something slightly different. So in terms of whether or not you think the decision made on Monday is a valid one or the decision made on Tuesday was a valid one, I can't give absolute answers to things like that, because the it depends response is always about trying to gather a little bit more information to understand the full story. But I think it would be possible for a person to have acknowledged short-term memory problems and nonetheless be able to make a decision, so long as they can retain it for the duration of the decision-making process. The third one is usually the sticking point about whether somebody does have decision-making capacity or not, and that's the using or weighing the information. And this comes back to the point I've just mentioned about it's not a subjective analysis of whether somebody's making a reasonable decision. And even though lawyers and lawmakers really do love the word reasonable, and you ordinarily see legislation peppered with the word reasonable, you do not see it in this definition. It is not about making reasonable decisions. This is about a decision-making process. It's not about the decision, it's about the process. So if I was to make a decision about whether let's use a COVID example, whether I was going to perhaps invite a few people to my house, I would weigh up, well, I don't know who they've had contact with. I do have contact with people who I would be worried about. And I sort of go through, if I do this. So in the end, I might decide to invite some people to my place on Sunday afternoon for a cup of tea and a scone, or I might not. But in getting, and you might make a completely different decision to me. How we weigh it up is a bit different, because what weight we give to things is different, and what we value is a bit different. So if you consider somebody perhaps leaving where there's no doubt whatsoever that a person has decision-making capacity, and they're asked to make a medical treatment decision, and they're told something like, you'll need surgery, and there's probably a 50% chance you won't survive the surgery, but if you survive the surgery and it goes well, then looks like you've got 20 years of life in you. Now, any health professional listening to me probably thinks that's an absurd example, but I'm just trying to be illustrative here. Some of us will think, wow, a 50% of chance of surviving the operation and going on to have a long, meaningful life, they're great odds. I'm going to do that. And someone else is going to think, my God, 50% chance of dying on the table, I'm not doing that. I prefer to have the few weeks left to me. So that's a very personal thing. And obviously to be able to communicate the decision, there will sometimes be people, their cognitive functioning might be quite intact, but they can't communicate. Similarly, in this Act, as with the other legislation, there are a few statements in the legislation to be clear. You have decision-making capacity, you're presumed to have it, unless there's evidence to the contrary. And you need to be supporting people to understand. So the obvious things about if a person's first language is not English, and particularly perhaps for people with dementia, where they might have been very good in English for a long time, but the cognitive impairment is such they're not as proficient in it as they were, or visual aids, hearing aids, all those types of things. You might be able to make some decisions, but not others. Maybe the person can well and truly make some decisions about how they spend their sort of disposable income of a couple of $100s a week. No grief will come to them if what they do with that money, they buy cigarettes, they buy alcohol, they give it to someone on the street, they hoard it. Maybe they can make those types of decisions, whether or not they're the decisions that you would make. But maybe what they can't do is run the business that they used to run. Or the person might have a delirium, or they, they've had a hit to the head, and perhaps with some time and other interventions, they will recover decision-making capacity. And there we have the third point. Just because somebody makes a decision that you think's unwise does not mean they lack decision-making capacity. It would be pretty extraordinary if any of us didn't think we hadn't made decisions in our own life that were unwise, or didn't internally judge other people making decisions that we think are unwise. And that last point, again, I've got that in the blue font about practicable and appropriate support. It's an expression that appears quite a lot in this legislation. And the examples that are used in the legislation are using information tailored to their needs. One of the things our office knows we need to do much better than we've done in the past is to produce resources that are much better tailored for people with disability. Giving people additional time and having discussions. So a 15, and this is no criticism of health professionals, but if somebody's got a 15-minute appointment with the GP because that's the way the system runs, maybe that's not enough time for that particular person. And one of the advantages, obviously, of more modern times is a lot of the technology we now have is incredibly beneficial for people with different types of disabilities. And those of us who don't necessarily need that technology ourselves need to become more capable of using that with other people. It's our responsibility to engage with people with disabilities. It's not up to them to make us engage with them. This slide's a little bit of a complex notion, and I probably can't spend as much time on it as I'd like, but the point I really want to make about this is there's a question as to who decides whether somebody's got decision-making capacity. What status does it have that somebody might form a view? Now, in all decisions really other than medical treatment, the assessment of whether somebody has decision-making capacity is a legal assessment. It's not a medical assessment. So VCAT can make a finding. The rest of us can have opinions. Doctors and other health professionals can have opinions. So fundamentally, if there's a matter before VCAT, then VCAT definitely is being asked to make a finding. And on the way they're writing up their orders now under the new legislation, I'm pretty sure, I'm sorry, I should have looked at one beforehand, but I'm pretty sure now they're sort of setting out the findings that they're making. So you'll probably see the order says that the represented person lacks decision-making capacity. So they're the ones who make the finding, the member does. They might consider all sorts of evidence from health practitioners, family members, the person themselves, of course. The person themselves should be able to comment on whether to challenge somebody else's suggestion they lack decision-making capacity. So VCAT's obvious. Secondly, and I'll come back to this, hopefully I'll have a bit of time to come back to this. If you are a guardian or an administrator, then there are some principles in the legislation. So even though VCAT might have appointed you to be the guardian or the administrator, you still need to consider on a case-by-case basis whether the person could make the decision if they got practicable and appropriate support. And you might be the source of that support, or you might advocate elsewhere for that support. So this is different, and this is complex, and this is a big issue our office has explored and continues to explore. If you've been appointed a supportive guardian or administrator, you have no authority to make decisions for someone. You're there to support someone, to provide practicable and appropriate support. But if you felt that even if you did that, the person really didn't have decision-making capacity, you probably need to get some advice and think about taking the matter back to VCAT. And the fourth group is, if you're a health professional who's been asked to provide an opinion, then obviously you're conducting an assessment. And if you are doing that, then I suggest you really need to have that definition of decision-making capacity in front of you to guide your evidence to the tribunal. What I'm going to do now is just take you through some of the legislative provisions. So again, for those of you who aren't so familiar with this legislation to start with, and for the non-lawyers, I'm sorry I'm giving you this sort of dense law, but for others, hopefully it's a helpful point of reference. So Section 8 is one of the really key provisions in this legislation. It talks about anyone who's got powers under the Act has to comply with various principles. And so what you see here now are some of the expressions I've already taken you through. We want to provide people with practicable and appropriate support so they can make and participate in decisions affecting them, express their will and preferences, and develop the person's decision-making capacity. If you think maybe about a young person who's just about to turn 18, they might have had parents and others around them who have been supportive, helpful, but sometimes maybe also a little bit protective, and it's a little bit different to having a child without an intellectual disability turning 18 to a child with an intellectual disability turning 18 in an emotional context, but not in a legal context. So it's really incumbent on service providers, family members, the community, to have confidence that people with developmental disorders and intellectual disabilities can develop decision-making capacity if they're given some support. Maybe not all decisions, but maybe many decisions. The will and preferences should direct decisions, and you'll see the expression there in point C about things being least restrictive. So that's some of the language that flows on from the last Act. This Section 8 applies to VCAT, it applies to OPA, it applies to all guardians and administrators, and all supportive guardians and all supportive administrators. So if that happens to be you, or you're someone advising any of those people, you really need to be familiar with these provisions. Okay, here's something a bit easy. What is a guardian? Hopefully everyone knows that. It's somebody who can make lifestyle decisions. What's an administrator? Someone who can make financial or property affairs. If you've appointed an attorney for personal matters or property matters, you do it in the one document. And the examples of things that are personal matters or financial matters is the same list as you find in the Powers of Attorney Act. I've got a slide about that coming up. Okay, now let's imagine we've got an application before VCAT. VCAT has to apply the law in making decisions. There's no instinct, there's no vibe, there's law. And in order to appoint a guardian or an administrator, we'll come to supportive appointments a little bit further down the track. So the focus at the moment is about guardians and administrators. Then the various items in blue is sort of what I'm going to focus on. So firstly, that the person has a disability. So I gave you that definition earlier on. Generally speaking, that's not the big issue and dispute in VCAT matters. Sometimes it is. Much more likely the dispute will be about whether the person has a lacks decision-making capacity. And then the next aspect is that the person needs a guardian or an administrator. Because simply because somebody can't make decisions doesn't mean they have to have a guardian or an administrator. And so this issue of need then breaks down into several sub-points, and VCAT needs to explore the will and preferences of the person. So for those of you who might have been involved in a matter before VCAT over the past 2 or 3 months now, my understanding is VCAT sends out, or they discuss maybe over the phone, to try to get a sense of what is called the proposed represented person's will and preferences. Now, some of you might not like that expression, proposed represented person or represented person, but nonetheless, that's the language used in the legislation. I know it sounds very detached and clinical, because that person is always an actual human being. It's Rosie Parker or someone else. But we want to know what Rosie Parker's will and preferences are. Could decisions be made by some other informal means? Who's got an interest in the application? And can we, as best we can, preserve existing relationships? Because quite often the prelude to an application to VCAT is complexities and collapsing of relationships, and the appointments might continue that. So that's something that the tribunal will be mindful about. And the last little bit in blue I've got at the bottom there is the order will promote the person's personal and social well-being. I'll give you the definition of that in a moment, but firstly I'll just mention that that expression appears in the Powers of Attorney Act and the Medical Treatment Planning Decision Act. So again, what we start to see is a little bit more synchronicity between those three pieces of legislation, which in terms of the work of our office are very interconnected. So what are some examples of personal matters? Where and with whom the person lives. I would suggest that for our office, when we're appointed guardian, the decision that we're most likely to make or to be asked to make is about where the person lives. Other persons with whom the person associates, medical treatment decisions. This is a little bit of a complex relationship. VCAT appoints, if VCAT thinks it's necessary to appoint someone to make medical treatment decisions, then they appoint the person to be the guardian to make those decisions. But if you are the medical treatment decision maker, you make decisions under the Medical Treatment Planning and Decisions Act. So I'm not going to go into that at the moment, but there's a sort of bridge between these two pieces of legislation about medical treatment. And one of the reasons VCAT will often not think there's a need, if I just take you back to that previous slide about can decisions be made by other means? If, for instance, a married couple, the husband, something's happened to the husband and the wife wants to make medical treatment decisions for him and she applies to be guardian to do so, it really wouldn't be necessary because under the Medical Treatment Planning and Decisions Act, there's already a hierarchy of people who could be medical treatment decision maker, and she probably already is. So it's unnecessary and an unnecessary limitation of a person's human rights to lay on a guardianship order. Whether the person undertakes educational training doesn't happen so, well, they're not decisions our office makes so much, maybe private guardians do. A new one as an example that's found its way in here is daily living issues such as diet and dress. And again, that replicates what's in the Powers of Attorney Act. We wouldn't like to see VCAT making orders where it drills down to the sort of humdrum, mundane issues about whether you wear a cardigan or a sweater or a blue dress or a pink dress. It really should be of a higher order type of matter that might go to religious issues around eating or gender-related issues around dress or concerns about a person's ability to swallow, those types of matters. And access to services, that's another big area of decision making, particularly for our office where we make many decisions about NDIS funded supports for people pursuant to their plan from the NDIA. That's the National Disability Insurance Scheme. In the legislation, there are many more examples of financial matters than this, but that's just a few. Make money available to the person. So I gave you that example before that maybe the administrator is going to manage the business of a person, but the person can still manage maybe their ordinary expenditure. They're not going to forget to pay their utility bills. They're very good at that. But what they can't really do is make a judgment maybe about where they should invest their money. Mind you, in the current environment, who really is that well informed about that? Okay. What I'd like to take you through now is if you're a person who's thinking of making an application to VCAT, some of the basics that you need to understand. And of course, if you are in that position, you are encouraged to contact our advice service because this is what we have a lot of content expertise in, and our advice service workers will step you through this. So firstly, any person can make an application. Our office isn't an equivalent to a child protection line. If you call our office for advice to report or convey your concerns about a person who might be at risk of abuse, neglect, or exploitation, whether it's your mother, your sister, your neighbour, somebody you saw on the street, and you think by calling us we will make that application, then we really won't. There are times we make applications, but they're quite rare, and there's a variety of reasons why that's the case. It's really a community responsibility. If OPA was to become the place that made all the applications, we would be structured as a completely different organisation and probably need to be about 20 times the size we are. So we're not making the applications. I think that's a really important point to make. If you have concerns about someone and the various factors that go towards the possibility of an order being made by VCAT, the onus is really on you. And if you're a professional, you might well have a duty of care. There's no filing fee. You don't have to have a lawyer. So for the lawyers listening, you might think, but people would be very well supported if they did have a lawyer, and I'm not going to disagree with that, but that's a choice for any individual, whether they think a lawyer is something they need and something they can afford. But most hearings, most people involved in proceedings don't have lawyers. So if you're a member of the general public, and the reason you're listening to this is because you are worried about your mother who you think has dementia, or your sister who you think is very disordered, whatever your story is, don't feel that this is beyond you as an ordinary member of the public. Ordinary members of the public are going to VCAT, dealing with these matters all the time. That's not to say that it won't be emotional, but you don't need to go off and do any study of law. You'll find the application on VCAT's website, and when you complete that application, and the application will take you through this anyway, you need to explain the orders that you seek. So for instance, I want a guardian to make decisions about where my mother lives, or I want an administrator to manage my mother's business. I don't think this is something she can manage anymore. Now, you might be estranged from somebody in your family, or you might think that somebody in your family isn't dealing well with the person that you're making the application about. But it's really counterproductive not to name those people, because VCAT's is going to need to hear. So if you're going to make an allegation, for instance, that your brother as the attorney is not making decisions as he should and is financially exploiting your mother, VCAT needs to know that, and they need to know his contact details. It's best to give the information. Withholding it will probably just delay the process. And identify the support needs of the person. So could they get to a hearing? What sort of support would they need? Could they have a telephone call? Now, of course, the COVID situation makes things a little bit more complex in that respect at the moment, but hopefully that won't be the case forever. And provide any evidence you have of the person's disability and how it's affecting their decision-making capacity. Or if you don't have that, you might know who their GP is, or where perhaps some evidence could be obtained. Having put in the application to VCAT, then you are required to give a copy of the application to those that are listed there. So the person themselves. I've had many conversations over the years, and my colleagues on the advice service similarly would have had innumerable conversations with people where they say, well, I don't want to give a copy of the application to my mother. She's got dementia, she'll just be confused, she'll just be upset, it'll be meaningless to her. We understand all of that. We don't know entirely whether any person's assessment of those matters is entirely accurate. It's your obligation, it's your legal obligation. If you think a person's going to be upset if they're told there's a guardianship application and a hearing before VCAT, then you need to think logically through to the next stages where they're going to be much more upset. Are they not going to be upset to get an order from VCAT saying a guardian's been appointed? Are they not going to be even more upset that the guardian makes a decision that they don't want? Upsettedness is upsetting to all, but it can't be avoided, but it probably can be managed best, I would suggest, by being frank with people. It's different maybe in your family situations, but certainly as a professional, I've nearly always found people prefer to have information put to them straight. You give a copy to the person you propose to be appointed and anyone with a direct interest in the application, and be prepared to attend the hearing, which of course at the moment largely is going to be by phone. So what will happen at VCAT? There are time specifications in the Act about how quickly the hearing needs to be listed. And so for those of you not so familiar with processes and thinking that legal processes often take months, years, etc., that is not the way at VCAT, although some of you will be thinking that you were involved in a matter which indeed did take weeks, months, or in perhaps years. But by and large, this is a very rapid legal response. Of course, VCAT can adjourn the matter, and there are a variety of reasons why they might do that. People aren't available, etc. But one of the key reasons they might do it is that they refer it to our Office for Investigation. And if we conduct an investigation, we've got powers to collect information. We could collect information from a bank statements. We can speak to people. We can collect medical evidence. So we gather that information, we answer the questions VCAT's asked us to look at, and we produce a report to VCAT. And that process can take several weeks, or there might be a delay in our ability to allocate the matter to a worker. So certainly there sometimes can be delays in that, but even if there are delays, hopefully what it means is that the process ultimately is one where VCAT can be satisfied they've had all the information they need to do their job. So when the matter goes to VCAT, they're pretty much always, or may I say always in my experience, a one-member panel. It is possible for it to be more than that, but that's just not the way it's done. So the member will hear from everyone, the member will consider the evidence, the member will consider the law, and then the member will make findings and orders. And anyone can go to those hearings, but you can't publish anything about them. And if you go to the hearing and you don't have a direct interest in the matter, the member's probably going to ask, why are you there? And ordinarily it's students trying to learn something about the system. And of course, that's a reasonable reason to be there. And usually if you approach people involved in the matter beforehand, they'll be okay with that. But if they're not, you might want to consider the unnecessary violation of their privacy. There's a little flow chart about the application process. I'll leave you to have a look at that in your own time. I know that Hilda sent some of our other resources that might be useful to look at too, which are a little bit more visual. How long do orders last? Guardianship orders usually are made for 12 months. That's been the practice in the past. I don't know that we've seen any change since the 1st of March. Administration orders are generally made for 3 years. They don't have to be. One of the things that any individual might choose to advocate to VCAT is that there's no need for it to be such a long order, that it would be more appropriate for it to be a shorter order. Again, it depends. These are generalities. And supportive guardianship and administration orders will also need to be reassessed because it's such a new area of practice. And even though I've seen 2 or 3 orders made so far, I can't remember now what duration they were made for. Even if an order has been made for 12 months or 3 years, or indeed a guardianship order I saw last year had been made for 5 years, I'd never seen that before, it doesn't mean they can't be reassessed earlier. You'd put in an application to VCAT, or indeed VCAT might decide to do that themselves. My next little bit is directed towards someone who is a guardian or an administrator, or indeed if you're someone who has an interest in knowing how a guardian or administrator is meant to be going about their job. So again, just to remind you, this relates to people who have been appointed under order since the 1st of March. So if you're a member of the public who's tuned into this, and perhaps your brother was appointed to be the guardian, but you're not quite sure whether he's doing things the way he should do them, if the order was made last year, there's a different decision-making criteria. Nonetheless, some of the elements are similar, but just bear in mind, I'm talking about the legislation that started on the 1st of March. So let's imagine I'm a guardian, and I'm going to make I'm a guardian at the Office of the Public Advocate. The Public Advocate's been appointed to make a decision for Rosie Parker. There she is. She's in a gem ward in a hospital. She would love to go home. She can't understand why she can't go home. Treating teams say she needs to be in residential aged care. So before I even make a decision for her, you may recall, I've got to go through those Section 8 principles first. I've got to work out whether Rosie Parker, despite VCAT making an order for me to make a decision for her, when I come along, can I provide some practical and appropriate support to her such that she can make the decision herself? That's my first step. Let's say that I can't. And, well, more to the point, Rosie doesn't have decision-making capacity. And so now I'm going to have to make a decision for her. So can I know her will and preferences? And if not know them directly from her, can I form a belief about them by consulting people who know her? If she's got a companion animal, I need to take that into account. You might wonder, well, what is a companion animal? It's not defined in the legislation. And in my view, you should just give it as wide a definition as you want. It's the budgerigar, it's the fish, it's the dog, it's the cat. If the most important thing to Rosie Parker is that she goes home to be with her dog, that's the most important thing in her life, that is a factor for me to take into very serious consideration. The companion animal to her may be more important than just about any other factor that I need to weigh out. And I can only override her will and preferences if it's necessary to prevent serious harm. And I'm using a very simple example here. The nature of the work in our offices are things that often are much more complex than this. But if we have a simple story of Rosie Parker needs support with transfers, she can't get up from a chair, she can't get up from a couch, she can't get out of bed, she can't get onto a toilet without assistance, and there's no package that's going to provide her with that assistance around the clock. She's at high risk of falls. She needs people to provide really all the activities of daily living. And so it might be that even though it's very clear to me she wants to go home, and I am doing my best to make that happen, in the end, I conclude serious harm will come to her if I allow her to return home. And so as a guardian, I could override her will and preferences. And if I can't form a view about her will and preferences, then I'd make a decision which promotes her personal and social well-being. So logically, the next thing to think about is, well, I'm throwing these expressions at you, but what do they mean? And the expression will and preferences is not defined in the Guardianship and Administration Act. And in our office, we have had many conversations about this as we've tried to understand this. So I've just plucked out a very simple component of this. Will is what motivates and initiates actions, deeply held beliefs and values, and usually stable. Preferences reflect priorities, likes, dislikes, develop from experience and knowledge. Now you could read lots of academic literature if you're interested, and it will be much more sophisticated. In time, we will see from VCAT that VCAT will, as they're asked to write reasons for decisions, start building up some jurisprudence and case law around this. But it's not for our office to do that. That's not something. It's not that we're avoiding it. It's just not the way law is made. We don't make it up. We just try to interpret and understand what's there. And case law will give more texture and nuance over time. However, personal and social wellbeing is defined in the legislation. And as I've mentioned earlier, this expression is in the Medical Treatment Planning and Decision Act and in the Powers of Attorney Act, but in neither of those acts is it actually defined. But in this act, it's referred to and it's defined. So recognise the inherent dignity of the person, respect their individuality, have regard to their religion, values, culture, and existing relationships, be respectful of confidential information, and again, we see the reference to companion animals. The reference to companion animals is new to this legislation. It wasn't in the old Act, but I would emphasise that my colleagues who are guardians would always have considered that as an aspect of trying to give effect to promote somebody's best interests. I've also used the expression before about serious harm. So if we just try to keep in mind our fictional Rosie Parker, so many of you health practitioners, you'll have met many Rosie Parkers over time. There she is, she's in the gem ward, she wants to go home. She says things like this: I would hate to go into residential aged care. I prefer to fall over on the floor in my home and come to harm than go into residential aged care, etc. So what we're trying to work out is, firstly, to be very clear, the harm is to the person. It's not harm that might come to others. It's not assuaging someone else's guilt. It's not for a middle-aged child to say, I would feel more comfortable and relaxed if my mother was in aged care and was being taken care of and that she was at home where harm might come to her. It might sound a little bit brutal to those of you who care about your family members, but our process at our office, because it's what the legislation requires, is to be concerned about the person. Our job is not to promote the rights of other people. Our job is to promote the rights of the represented person. So Rosie Parker, for the purposes of some sort of visual for all of us here. And then you've really got to examine what is the nature of this serious harm. So the last thing in the world we can say is that if we had a whole group of people like Rosie Parker in a gem ward, and there are various possible harms that might come to them if they return home because of the state of their cognitive impairment and their support needs that can't be met. Each of those people is different. And so again, you will come up against the maybe frustrating, it depends sort of response. And sometimes I know people feel that the guardians in our office make decisions inconsistently. And my response to that would always be, well, firstly, you are welcome to challenge the decision-making process of guardians in our office. There's a process for that. But what's most likely to be at play is that the guardian in any particular matter is dealing with the particularities of that matter. And what you see as an inconsistency is different outcomes for different people. But what I'm, as a lawyer, interested in is whether there has been compliance with the legislation. The consistency must be about compliance with the legislation. Outcomes, different outcomes might be reached. And yet to me, that's not the problem. Now, if we think about Rosie Parker, there may well be harms to her if she moves into residential aged care, depending upon what you know about her. Maybe she is an extremely reclusive person. Maybe she's a person who there are things about her own home that cannot possibly be replicated in a residential aged care that are so meaningful to her that to be separated from those will cause her significant harm. And similarly, and usually from family members' point of view, they find it a bit easier to identify the harms that will come to her in her home. She'll let the water boil over. She'll fall. She won't wear her security pendant. She will eat food that has become contaminated. She won't get proper nutrition. She won't drink. She won't take her medication at the right time. Well, can we manage some of those harms? Can we mitigate them? Maybe we can't. Okay, so conscious of time, so I just want to, don't really want to not give proper service to this concept of supportive guardians and administrators. But so this is a new power that VCAT has to appoint a supportive guardian or a supportive administrator, or both, different people, same person, if satisfied that firstly the person consents. Okay, so you can't compel someone to have, you can compel someone to have a guardian or administrator, but you can't compel them to have a supportive person. It wouldn't work. It wouldn't be consistent with the whole ethos. And VCAT also needs to be satisfied that if the person is given practicable and appropriate support, namely in the form of this appointment, then they will have decision-making capacity and that the order will promote the person's personal and social well-being. So I've seen a couple of orders that VCAT's made. I've also read a couple of decisions where VCAT's explored the possibility of appointing someone, but at least from memory, in one case, there wasn't anyone who could be appointed. So it became a moot point. What can these supporters do? They can do similar things that a supportive attorney or a supportive attorney for financial and or personal matters can do under a power of attorney, a supportive power of attorney that you can make under the Powers of Attorney Act. Collect information, so it gets over the privacy barrier. One of my colleagues conducted an investigation recently, matters yet to be determined by VCAT, but where a friend has been trying to support this person, but they come up against the privacy barrier. And so possibly if the person had an order from VCAT saying they're the supportive attorney, maybe there'd be less of a complication with that. So collect information, communicate decisions, etc. So look, I'm sorry, I feel like I'm really paying lip service to this as an issue. If you think it's a possibility that such an order could be made, it would be great to have a conversation with somebody on our advice service to talk that through, and certainly for you to explore it with VCAT. There are various, I'm not quite sure, I probably should have had slides in here explaining what the duties of guardians and administrators are, because there are some duties, and certainly they're outlined in our resource about good guardianship and our administration guide. But there are some duties also for supporters. So just for the sake of time, I won't go through that at the moment, but they're there. Which gets me to the last slide about the resources that we have and that I've mentioned. Guardianship Guide and the Administration Guide are quite detailed resources, very much aimed at people who are appointed guardians, administrators, but also anyone else. You might want to be making sure that a guardian or administrator is doing things as they should do. There's a flowchart. It's quite detailed, but the legislation is complex, and we've tried to reduce it to a visual form. We hope people find that helpful. And then some more straightforward resources that you might find useful to give to clients. So I'm going to finish there and I'll get rid of that PowerPoint presentation. We'll open the panel up, and Emma and Hilda can facilitate some discussion if we've got some questions.
Thanks, Claire. There is a question from Vicky. What kind of evidence would VCAT need to be satisfied that there was financial abuse happening by a person's family member?
Well, VCAT may not have to make a finding that there's been abuse. That might be the catalyst for bringing an application to VCAT. So probably, if I can just give a couple of different types of examples, if the reason you brought an application to VCAT was, let's say there's a daughter who's the attorney for her father, and a sibling is pretty worried about what's happening, and the person who's the attorney is not explaining. They say, it's none of your business, Dad doesn't want me to talk to you, it's private. And so the sibling chooses to take the matter to VCAT. Now, it may become apparent through an examination of banking records or transfer of resources that the attorney hasn't acted appropriately, might even have acted dishonestly. And in that case, it's not so much that VCAT has to make specifically those findings as they might say the person's in need of an administrator. They might revoke the power of attorney, and there are criteria for doing that. But sometimes they don't really have to make those sorts of findings. The issue is more about the need. So then if I play around with that example just a little bit, we've got a daughter who's the financial attorney for her father, and there's a brother. And the brother's not happy with the way the sister's doing things. But what's the backstory to this family? Maybe the father's appointed the daughter because he trusts her and he doesn't trust his son, and he doesn't want his daughter to tell the son anything. And so that becomes apparent during the course of the hearing, and VCAT says, well, we've got no concerns, and your father has a right to privacy, so you don't have to, we're not allowing you to have access to his bank records. I've seen many written decisions from VCAT along those lines. On the other hand, there might even be a situation where maybe the daughter, she's been appointed attorney and she's done nothing wrong, but her father trusted her when he had decision-making capacity, but now he's lost decision-making capacity and he's suspicious and paranoid. And he's saying, I don't want you to do this, or why don't you give me more money, or you're controlling me now. So that's a very sad position for the attorney now to be in, because they're actually only trying to do their job. They're doing nothing wrong, but it's actually become untenable for them to do it because the nature of the impairment of the person with a disability, her father, is such that she can't do the job. So look, there are many variabilities as to why an administrator might be appointed when there are financial issues. And even though our office certainly does hear many allegations of financial abuse, it's less, and I have read over time every decision, reasons for decision that VCAT has ever published. They don't write reasons for every decision. It's rare, numerically it's rare for them to write reasons for decisions, but I've read them all, and there aren't really many findings where they say the person has acted abusively. Usually there's a little bit more going on, but I appreciate that often it's going to be concerns about financial abuse that's the catalyst. But in terms of the evidence, if that's an allegation, that's the sort of thing that maybe when our office conducts an investigation, if we get bank statements, we might say to a person, well, when I first worked at in fact, the very first investigation I did personally at the Office of the Public Advocate, I got hold of bank statements and I could see that money had been spent. This lady lived with her daughter and son-in-law, and I could see money had been spent at various places. And I said to the son, so money's come out of her account at this ATM and this petrol station and this retailer. Explain that to me. And he was an evasive character and he didn't explain it to me. And so all I could do was report to VCAT that I had this information. I put these questions to him. He hadn't answered those questions. And maybe not so surprisingly to any of you, the VCAT member revoked his appointment as attorney and appointed an administrator. But what they never did was make findings that he had financially abused his mother-in-law.
Thanks, Claire. We have a question from Margaret from Carers Victoria, and Margaret was interested in the example that you used at the beginning of the webinar when there is an older person in hospital and there are concerns about discharge. Dementia may be an issue or not. How has the new legislation impacted on applications by hospitals for guardianship? Is VCAT appointing supportive guardians and supportive administrators in the first instance?
It's hard to comment. I'm probably not the best person to answer that question because I'm not invited, so I can't really comment on what the flow of applications and orders has been since the 1st of March. And of course, it's been complicated because of the COVID restrictions, which would have impacted everyone as to whether they made applications or why they made applications. But I think fair to say not many orders for supportive appointments have been made, which isn't to say that perhaps on each and every occasion the member is contemplating the possibility of it. And in fact they should. And because that's what's, you don't have to make an application, I didn't mention this before, but you can make an application to VCAT for the appointment of a supportive guardian or administrator, but VCAT can make such appointments even if no application's been made. So if somebody's made an application for guardianship or administration, then VCAT has the option open to it to appoint a supportive appointment. So again, all I can know is what I glean from the decisions that I read and any information I'm getting from my colleagues, and I'm not getting as much information as I might have if we were all in the office. But my impression is that members are working through it as a possibility, but there haven't been many orders for it yet. Yeah. Whether or not supportive appointments are going to lend themselves so much to that sort of cohort of people with a declining dementia, is going to be a declining cognitive impairment as opposed to someone else with a more stable impairment. And we'll just have to wait and see. I'm not saying that it can't happen, but it would seem that the group of people perhaps who would benefit the most from a supportive appointment would be people with acquired brain injuries and mental disorders and intellectual impairments, perhaps more than people with dementia.
Thanks, Claire. Daryl has asked, how does one go about establishing if there are orders in place as family members may claim to have authority they don't hold?
Yeah, that is a very good question, and thank you, Daryl, for putting that. Yes, people do often claim they have authority. They might legitimately believe they have authority, or they might be deliberately misleading on that point. It's a completely reasonable thing. If somebody is purporting to exercise power to make a decision about another person, they must produce the proof that they can. So if somebody says, oh, VCAT appointed me to be a guardian, you should ask to see a copy of the order. That is a perfectly reasonable thing to ask for. One, for the veracity of the claim that there's an order. Two, to see whether the order remains in place. It might have expired 6 months ago. Three, to see that the powers a person purports to have, they do have. So for instance, if VCAT appointed the daughter of Rosie Parker to make a decision about where she lives, and that's the only power in the order, for Rosie's daughter then to tell the care facility, I don't want my brother visiting, don't let him visit, he's forbidden to visit, is not a power she has. And so when Rosie's brother says to Rosie's daughter, says to his sister, show me the order, that's a perfectly reasonable thing to do, because the person's purporting to have a power that they don't have. So if the person won't give you the order, you can contact VCAT. I hope I'm not speaking, I hope there's nobody from VCAT who's going to be upset by that, but these are matters of public record. If somebody's purporting to have a power, they need to be able to produce it. And the same point goes to powers of attorney. Quite often, there are a variety of powers of attorney. It's a very cluttered landscape because there's been legislative reform over time. But if somebody's saying they've got a power of attorney, you need to see it, and you need to see they've got the powers that they say. So again, I might make a power of attorney and I appoint my sister to be able to look after my financial affairs if I'm in a position that I can't manage them. But what I don't want her to do is to sell my house. And so I put a condition in my power of attorney that says she cannot sell my house. Now, let's imagine I'm then involved in some sort of accident and I have a traumatic brain injury and I can't manage my financial affairs, and my sister decides she's going to sell my house. Well, if nobody's asked to see that document, they're not going to know that she has no power to do that. So if somebody is asking you to respect and implement a decision that they say they have authority to make about another person, you should in fact ask to see the source of their power. Because as a principle of law, and I should have said this at the beginning, none of us have the authority to make decisions for other people unless there's a lawful basis for it. And a lawful basis for it is a guardianship or administration order or a power of attorney.
Thanks, Claire. I'll just give you a bit of a heads up, Claire. We've got 10 questions here. I don't know how we'll go with getting through them all, but I thought I'd let you know. I might give you these two questions together because they are a little bit similar. What is the expected outcome of this new legislation? Is it expected that there will be an increase in supportive appointees and a significant decrease in the full guardian and administrator appointees? And what is your opinion on the Act's operation since commencement in March? What do you see are the main areas of improvement in this Act or with VCAT, if any? So
okay, so, yeah. So with the first part of that question, it's a bit speculative still. I mean, we did speculate about these types of things in our office before the commencement of the Act, whether we thought there'd be more orders, fewer orders because of the supportive appointments. I'd say it's too early to say. That's the sort of analysis that researchers probably will be able to make some sense of over a much longer time period than we've had. I think, though, it would be fair to say we would like to see orders with more constrained powers, because that would be consistent with the legislation, or more time limited, and indeed supportive appointments where that seems to be a possibility. And I think my impression is, from the limited exposure to information I've had myself, is that VCAT have been very willing to grapple with that. So that goes to that. I mean, and I'd probably, perhaps just as a rider to that, I should mention that one of the provisions in the legislation is if VCAT's If VCAT has decided to make an appointment of a guardian or an administrator, the next question obviously is, who is that going to be? And in terms of both appointments, there's a preference, there's a legislative preference for appointing someone known to the person. So in the case of guardianship, the public advocate always has been and remains the guardian of last resort. So I guess what we'd like to see is that maybe, even if there's not necessarily significantly fewer guardianship orders, that maybe there are fewer appointments to the public advocate, because the legislative preference is for the appointment of people known, so family members. And in many instances, that's completely appropriate, and in some cases, clearly that's not, but that's a case-by-case basis. And I think the other part of what Emma read out, I've probably lost a little bit of the detail, but how do we think the implementation of the Act's going so far? Well, our organisation had a online discussion yesterday with two of the people who work in our investigation team, having a facilitated conversation about their experience so far. And so, you know, that's probably the best source of my information, what my colleagues are telling me. And I think what we're finding is probably because we're all very mindful of the new legislation, and we've worked on our own resources and at VCAT's end and at our end, that there has been a pretty methodical way of approaching the new legislation. But I think even though there's a lot of significant changes to this legislation, the world wasn't going to change overnight. To sort of reiterate the point I was trying to make at the beginning, I think the way we'll get a change in our community about respecting the rights of people with disabilities more is if we all do that. VCAT's our last resort stop to have people. Yes, we should only be getting to VCAT if we have to. So the implementation of the Act, certain organisations are empowered, VCAT and OPA, but the true success of the message of the legislation is in the community. So again, far too early, people don't know enough, but all you health professionals and legal professionals who are listening in, I would see that you are part of the agents for making that happen.
Is a supportive guardian administrator required if a person has provided written verbal consent to a family member to assist them with Centrelink as a nominee? When would this need to be formalised by VCAT? Yeah, again, that's a good, so what we now have are many options that didn't necessarily exist a few years ago. So certainly people can go through those processes on a case-by-case basis. So you could set up an arrangement with a bank or Centrelink, I don't know, maybe many other types of providers, My Aged Care, where you're the nominee. So it might be perhaps a family member is receiving services, particularly this is something that happens through My Aged Care, that you can nominate nominees. Now that will get you over the privacy hurdle, and that might be enough. Some people find it's not enough, or they prefer not to have to go through that process with individual organisations, so the one order is going to be a bit more efficient. Or of course the person, if they wish to, could appoint you to be their supportive attorney. So there are those three possibilities, four possibilities. There's a complete informal aspect, which I'm sure many of us have done with family members, where somebody does need a bit of support, you sit by somebody and you help them pay a bill. You know, you've not disclosed yourself to anyone, but you've sat with them and you've got into their banking and you've helped them do a BPay. So that's completely informal. That's all good. If the person's sharing that information with you, that's not an abuse issue. That's loving support. May there be more of it. Then there's a level up, which is, well, actually, I'd like Centrelink to know that they're allowed to speak to you. So go through that process. Or then there's the next level, the person makes a supportive attorney appointment because they think that will be helpful for them. And then there's a VCAT option. So the thing is, because so much of this is quite new, we can't expect everyone in the community, all service providers necessarily, to be familiar with all of these things. And so it'll take time for people to become familiar. And the other thing is that Victoria is actually, I'm happy to be corrected about this, my knowledge might be getting out of date, but I'm pretty confident no other jurisdiction in Australia has yet gone down the path Victoria has. So we're sort of, the Parliament of Victoria has
really been the reforming state thus far in this area.
We have two similar questions. Can someone, for example, extended family, make an anonymous tip if they believe an elderly disabled person is not being treated the best? If so, who is the best authority person to alert? And a similar one, as part of duty of care, we must report physical and financial abuse. Where do we report financial abuse?
Yeah, again, there are so many variabilities to those questions that it might be, if you have those experiences, you're best, calling our advisors to sort of talk through the specifics of them. But if you've got concerns, depends upon the nature of the concerns and which would be the body that might have some authority to do something about it. Police is an option sometimes. Perhaps contacting, if you think the person would be able to instruct a lawyer, you might, with elderly people, you might think about seeing if they want to contact Senior Rights Victoria, or you empower the person to get information for themselves. It's the same as, say somebody who's in family violence and there's no issue that they lack decision-making capacity. You can't make decisions for them to get them out of that situation, but you might be able to give them some resources for them to think about how they might do something about it on their terms. So there's that aspect. If you think, so I suppose perhaps one part of that question might have come from me saying, if you call our office, we're not necessarily going to be the place that makes the applications. And if I can just explain, because we get calls like this every day. Let's imagine Rosie Parker's daughter calls our office and says, my brother financially abuses my mother. Now, what do we know? We only know what she's telling us. Quite likely, should the matter proceed to an application to VCAT and it's referred to us for investigation and we now speak to the brother, we will get another version. We will get a more nuanced story. So for us to leap off and make applications to VCAT simply because somebody makes an allegation is very problematic. We don't ever know whether Rosie Parker lacks decision-making capacity. Maybe she likes to give all her money to her daughter, not her son. Isn't that her prerogative? So it becomes very complex. In terms of any organisation's individual duty of care, that's not something our office can give people advice about. What we can give you advice about is what the processes are at VCAT. I don't know that a duty of care would be satisfied, and frankly, sometimes it feels like this, that some people call our organisation and they think because they've told our advice service something that they've therefore discharged their duty of care. If you call us, we're giving you information that will help you consider how to fulfil your duty of care. But just telling us and it becoming a note on a file that may well be anonymous in our database where it's not explored and challenged, I don't know that you can really think you've satisfied your duty of care, but they're matters for you to explore yourselves. One way in which you'll do it is if you have concerns a person's been financially abused, is to put the matter to VCAT. Now, VCAT will have access to information that you don't have, and they might come to a conclusion the person's not been financially abused, but you've done what you need to do.
Thanks, Claire. We do have quite a few more questions, but I'm aware that it's at 11:28. So I don't know if we'll have time to go through the rest of these questions if we're aiming to finish up at 11:30. Shall I give you one last one?
Yep, let's do one more.
Section 40 allows a guardian to bring legal proceedings on behalf of the represented person. What if the administrator does not agree with the decision to commence proceedings?
Yes, so that's a particular power that VCAT can give to a guardian or an administrator to bring legal proceedings, but it's going to have to relate to the area of the personal matter. So what sort of legal proceeding could a guardian make that relates to a personal matter? It's going to be quite a limited range of matters, and frankly, really almost the only one's a family violence intervention order. So it's hard to see what opinion of an administrator could be relevant to that. But whether it's a legal proceeding or any other type of decision, there is a process if there's disagreement between guardians and administrators or disagreements between attorneys and for personal matters and financial matters. So that's probably the bigger issue. So there's two aspects. How do you resolve disagreement? What are the processes? And secondly, what's the scope of an order? So with a guardianship order for legal matters, I've thought about this a fair bit, and I can't say that there are many legal proceedings a guardian can really be involved in. Possibly making an application for victims' assistance under the Victims Assistance Act, and possibly, as I say, about family violence matters. But otherwise, most legal proceedings really are much more likely to relate to estate issues. So it's much more likely to be an order that's given to an administrator. Having said that, one of my colleagues did email me recently a guardianship order in which the public advocate's appointed guardian with power in relation to legal proceedings, but I didn't get a broader sense of what that story is about, so I had to presume it's probably about family violence.
Thanks, Claire. I'll hand back over to Hilda.
Okay. Thank you so much. As you can see, it's quite a very complex and in-depth area, and I can tell by the questions that have been coming through, which have been really fantastic. We apologise that we couldn't get through all those questions, but I really encourage you to visit our website. We have a number of resources, and also, as Claire mentioned, you are most welcome to contact the advice service, so you can call them. The other way you can make contact with us is through an email, which is opa_advice@justice.vic.gov.au, and you'll find that on our website. You have my email. Please send me through any feedback or any comments that you might like to make. I did notice that we had a lot of people logging in a little bit late, and I just want to know whether there are any issues with that. And so I'm just going to leave it there, and I'm going to thank Claire very much for taking us through that presentation. I was a bit worried because I don't think I saw you drink any water, and that's a lot of talking for an hour and a half, so I think you should have a break. And Emma, thank you very much for being our moderator today. Thank you for choosing our event. There were so many events during Law Week, and we thank you for joining us today. This session has been recorded, so if you're interested in getting a copy for your colleagues who weren't able to make it, just send me an email. Thank you, everyone. Enjoy the rest of your day. Stay warm, it's very cold, and enjoy the rest of Law Week. Thank you. Thanks, guys. Bye.